Hello, I'm Debbie Ford with the League of Women Voters of Mississippi, and we are pleased to bring information to help you, the voter, when you cast your ballot in this general election. We've been hearing every day about the presidential election, but did you know that there are other races on the ballot? Well, today I am speaking with a candidate for the Mississippi Supreme Court. Briefly, I would like to touch on the role of the Supreme Court in Mississippi. The court reviews decisions of law and fact made by trial courts in the state. It is the court of last resort among state courts. Mississippi has 9 Supreme Court justices who are elected from 3 districts in nonpartisan elections and each serve 8-year terms. With me today is Justice Josiah Coleman, who is a candidate for Supreme Court Justice for District 3, Place 3, which covers North Mississippi. Welcome, Judge Coleman.
Thank you so much.
I do thank you for participating in this interview, and what I will do is ask you 3 questions, and you will have 2 minutes for each response. So here is your first question. What are your qualifications that make you a better candidate for the position of Supreme Court Justice?
Well, in addition to the law degree that I got from the University of Mississippi, which is, of course, a law degree all of the Supreme Court justices and candidates are going to have, or at least it's not always going to come from Ole Miss, but everybody's going to have a law degree. I've also earned an advanced law degree from Duke University Law School. That's an LLM is what it's called, and it's in judicial studies. And so in that format, I was able to go to the law school at Duke with a lot of judges, federal and state judges from around the country, as well as a couple of judges from other countries. And so in that class, we spent a lot of time breaking down Supreme Court, U.S. Supreme Court opinions, studying how judges do that, the different, what they're called are modalities of interpretation, originalism, textualism, living constitution, and debate those. And I think that's sharpened my abilities to do the job well. And also, I would have to mention that going back to the time that I was in law school, I became pretty interested in just the nature of the law and how it affects us as a society and how individuals interact with it, and just basically the background of it, the reason it should hold sway over us. And so having been interested in that and just studied a lot of this on my own, I think has prepared me in a way that might be fairly unique for the position.
Thank you. The second question. What made you want to become a Supreme Court Justice?
Well, I think to answer that question, I would kind of tie back into the last part of my answer to your first question, in that it's just something that's interested me since actually even a little bit before law school. I was a history and philosophy major as an undergrad, and I took a class on the philosophy of law at Ole Miss that was really interesting and got me thinking in ways I had not thought before about the law, and challenged a lot of assumptions that I had coming out of high school about the nature of it. And so I would have to point back to that as just being a sparking interest. And I just feel like as the time went by with my in law school and the way I practiced law, I did a lot of appellate work. The skills that you see that a Supreme Court or an appellate court judge needs, writing, research, attention to detail, those things were developed, and it just kind of instilled in me a desire to have this position. As well as I grew up in a family. I would be remiss if I didn't mention that I grew up in a family where my grandfather was an appeals court judge and my dad was a lawyer. He didn't become an appellate judge until later in life, until I was an adult. But certainly I was around that a lot.
Okay. The last question. The Mississippi Supreme Court affirms or overturns the rulings of the lower courts. What standards do you apply to your decision making?
So that's a fairly involved, well, the question is fairly straightforward. The answer is fairly involved. And the short answer is that it depends, but I'll give you an example. So if we're looking at a factual determination that a jury or a trial judge sitting as what we call the finder of fact has made, the appellate court gives a lot of deference. So if the question is whether or not a witness was telling the truth, the jury is in the courtroom with the witness. The jury is able to see the witness, watch the witness's body language, see whether or not the witness is willing to make eye contact, those traditional sort of things that we watch to determine credibility when somebody's speaking to us. When we get the transcript, when we get it, the case at the appellate level, we don't see that. We're not in the room. We get typed out transcripts of what the witness said, and you can't make this credibility determinations. And so there are certain standards built into our law that acknowledge that, and so we view factual determinations with a lot of deference. However, on the other hand, what we call questions of law are reviewed with a standard that we call de novo, which just means we owe no deference to the trial court. And an example of that is when we interpret a statute. So a statute is the legislature's codification of the law that sets some sort of a policy in words. And when the lower court interprets that statute, and then it comes up to us, and the question is one of statutory interpretation, it's our job to say what the law is on that, and we don't owe deference. We just start over and start that work again. So it just really depends on the type of question that's before the court.
Okay, thank you. And thank you for spending time with us today. And voters, to find out more about what's on your ballot, go to vote411.org. That's vote411.org. Thank you.
Thank you so much.